Good morning and welcome to our Facebook live broadcast. My name is Steve Altishan. I'm the Director of Client Partnerships here at Landerholm Family Law. And today I'm here with our founding partner, Louis Landerholm. Hey, Louis, how you doing?
Oh, I'm doing well. How are you, Steve?
I'm doing well. So, Louis, today we're going to talk about parenting plans, what they are, what they do, why they're important to get right. So let's just start right at the basics. What is a parenting plan?
So parenting plan in Oregon is the actual plan that dictates how parents are going to operate on a day-to-day basis post a custodial filing or a divorce filing when kids are involved. The term custody in Oregon refers to decision-making, like major medical, school decisions, and some religious decisions, but the parenting plan is everything else. Who's going to have them, on what days, on what evenings, who gets to take them to certain sports, certain activities, and who gets to make those decisions. So it's really to me, it's the meat and potatoes, and it's the most important part of a judgment and of a custodial matter. But sometimes it doesn't come across as being the most important piece. But in reality, most people end up needing to spend more time on their parenting plan than they do on who gets custody.
Well, that makes sense. So you mentioned about them going into the judgment, the divorce decree. Are parenting plans required in every case? I mean, do you have to have a parenting plan if you're getting a divorce or if there's custody involved?
So it depends on the judge and it depends on the county. In 99% of cases, you're going to have a parenting plan. There's some rare circumstances. I mean, it could be as vague as the parents have agreed to, just work out and negotiate what the schedule is going to look like. With older teenagers, you may be able to get away without a parenting plan, but in 99.9% of cases, you're going to need a parenting plan for the judge to sign off on the judgment.
Got it. So before we get into some details of what kind of things can go into a parenting plan, let's back up a second, because you had talked a little bit about custody and made me think, what's not in a parenting plan? There's a lot of stuff that goes into a decree. What's not some of the things you put into a parenting plan? I mean, does support go in there?
No, your child support is a separate section of a judgment. So your child support would be there. How all of your debts and assets are divided are in different areas of your judgment. The custody determination is separate. The parenting plan is really everything from the schedule, also how you're going to handle any differences, or if there's any sort of decision-making that needs to happen from, if you had joint custody, like from a mediation standpoint or from a day-to-day standpoint, even, as detailed as who can approve a haircut. It can get very detailed and very intricate, but it's really just the kids and the day-to-day operation of how the parents are going to manage, that between the two of them and co-parent.
Yeah. That kind of leads to a question then. Sounds obvious, but I don't know that it is. Who creates the parenting plan? Who makes it? I mean, how does this thing come into existence?
So ideally, the parents get together and they negotiate, and they, with their attorneys or on their own, come up with an agreement, or a mediator. They come up with an agreement as to how they're going to exchange the children, what schedule it's going to look like. But ultimately, if the parties can't decide, then it would go to a judge, and a judge would order the parenting plan and order the schedule. And for most clients, for us, we really work hard to help them to create the parenting plan when they have control over it, rather than giving it to a judge who has a few hours or a few days even to hear testimony. But still, the judge doesn't really know, the whole story and what's best for families. So if you can keep that to yourselves and be able to work with your soon-to-be ex-spouse, in my opinion, that's best for everybody. And it's not going to be easy always, but trying to come up with the schedule and the details, that better than a judge would. So anyway, if you can negotiate that, I highly recommend it.
That sounds brilliant. I mean, that sounds like the way you would try to do it. Kind of circling back a little bit to the importance of a parenting plan. I know you kind of talked about how it sort of is the document, the cornerstone of how parents are going to relate going on. I mean, it seems like there's a lot of family, not just for the parents, but for the kids, good reasons to have a parenting plan that's well thought out and doesn't have to be fought over all the time.
Yeah, I mean, if you can avoid going to court and feeling like you have to rush to court over and over and over again, that's better for everybody. For some families, a flexible parenting plan where you're able to co-parent and you can figure it out, that works well, and that's great. But a lot of people, they're split up for a reason, and you're not a couple for a specific reason, and a lot of that is that you can't get along. And so you want to build in specific clauses so that you don't have to constantly fight about what time are the kids coming over? Am I getting them this weekend? What happens if they're sick? What happens if, there's a day off of school? What happens if, you split up when your kids were young and before school, and then school comes into play, and now there's a whole nother set of rules, or if one parent moves away from the other parent. All of these things impact parenting plans. And, those things are pieces that we see all the time, and we work with clients all the time. And so what we try to do when we're working with clients is we try to look into the future as far as we can to be able to, we're going to try to help with and advise on perceived problems on parenting plans, where there's going to be an issue, and then try to plan for that issue. A school is a big one. When you go from young children to a school plan, that just dictates how things are going to go. Who are they going to be going to school mainly with? And on the weekends, what happens then? And on teacher in-service days, and then in the summertime, how's that going to work? So, how are camps going to work? All of these things, and vacations, all of these things get built into a parenting plan. And, my opinion is that the one size fits all plan that are out there, they just don't work, because all of these things are things that are going to be original and unique to your family. And so you need to think through these, ask the questions, and make sure that you've got a well thought out plan so that you know how the rules are going to work and how you're supposed to co-parent together.
That makes sense. I mean, there's different people have different work schedules, like you said, kind of live in different areas. Can parenting plans then deal with even more specific or more unique or more urgent kind of cases? I mean, can you have your parenting plan include, let's say, issues where there's safety concerns? One of the parents maybe is abusive even, or something like that, or a special needs kid, or you're living in 200 miles apart. I mean, can parenting plans handle all these kind of other different situations?
Sure. And we build those plans all the time. I can say that those type of plans are more difficult for parents to figure out on their own, just because they don't know what the options are. Substance abuse is a huge one. How do you plan around the substance abuse disease so that you can allow the parent to have time, but you're taking into consideration the safety concern of the kids. Young nonverbal kids are going to have larger safety concerns than older kids who can self-report and who have cell phones and who can call and who can make sure that they're safe on their own. So every age is different. If we need to get professionals involved, we get our custody evaluators involved, but then they'll also make parenting time recommendations. So those are reserved for the more either high conflict case or the more difficult case. Special needs is a reason that sometimes we need a psychologist to get involved to say what's best for the child, because the standard for parenting plans is what's in the best interest of the child. But sometimes that's not as easy as it sounds, especially with a move away case. Move aways are hard in general. If the parent is going to try to take the kids a farther distance away from the other parent, those are not easy cases, and because you still have to prove it's in the best interest of the child and not in the best interest of the parent themselves. So all of those issues, definitely, we help a lot of clients with those because they are so difficult and there's so many moving parts, and it's hard to navigate that on your own.
Coming back to the scheduling, you talked about a little bit, and in terms of who makes some of the decisions, and it sounds like you were talking about parenting plans can deal with that, but could you just give us a little sort of overall picture of, having not maybe put in very specific things, what sorts of decisions can be made by the parents depending on where the kid is residing at the time? If the kid's with the non-custodial parent, does the custodial parent, what kind of decisions in general does that parent get to make about the child?
So it gets more into custody law than it does into parenting plan law. But typically, and it can be modified based on the parenting plan and based on the custodial agreement. But typically, like emergency situations, if you're the non-custodial parent, you can engage emergency help. As far as other decisions, most are made by the custodial parents that are big decisions. Your parenting plan doesn't have, I mentioned earlier, like getting a haircut. Now, most parenting plans don't have those provisions in there, but it's something that the parents, figure out and they work together. But if there are issues, sometimes they need to be built into a parenting plan. A lot of times, people will either get divorced or go through a custody matter. They've never had to operate separately. And so you don't really know where the problems are going to be until you have experience. And so trying to plan for some of those, but then inevitably sometimes changes occur, and that will either require a modification later once you have specific pieces that aren't working. And that modification can either be through agreement or through the courts.
So looking at how situations change, you were talking about over time. You said that parenting plans can deal with that. Are you talking about something like, well, between the ages of 5 and 12 or whatever, this will be the schedule for school, and then at another age, a different schedule will kick in? Is that how it's done, or is it more like we agree to form something else at a later time, or can you do either one of those kind of things?
You can do either one. A lot of times what we see are what we call stepped up plans or a tiered plan, where you'll start with pre-K kids who maybe their needs are different and they're in home base for a longer period of time, and then you're transitioning to say a week on week off plan once the kids are in school and say around the 6 or 7 or 8. Now there's psychologists who have done a lot more work on this these developmental stages than I have, or that I've, obviously read. But we listen and we talk to a number of psychologists and child's therapists who, these are general recommendations where at the earlier stages, they're at the younger stages for the kids, they're going to have one home base, and then that's going to transition as they grow and as they develop into having more equal time between the parents. Some plans go directly to week on, week off, if or a 50-50 type of plan. There's multiples. That's like a 3-4-4-3, where you split the week for younger kids, but then when they get to be older, they don't like that midweek transition. So then, typically, a lot of parents will transition to a week on, week off. So there are some benchmarks that are sort of typical that we see, but they are guidelines for parents. It doesn't mean that's right for your family. Some families, a week on or every other weekend plan is just fine, and that's what everybody wants because it's best for the kids, it's best for the parents. But there are some transition periods, like school is a good one, preteen, and then you get to be late teenagers, and parenting plans are hard to apply anyway. So, they're sort of thrown out the window to a certain extent when they get to be older, since they can vote with their feet or their car. And so it gets to be, much more difficult at the late teenager age anyway.
A lot of stuff you can do, obviously put in the time frame, when's and all that stuff. But what about do parenting plans touch on like the where and the how exchanges happen? I know that a lot of, the stuff breaks down in terms of who picks up or drops off, and, where it's all done. Does that get into a parenting plan?
Yeah, all of that can be in a parenting plan. It typically is. A typical plan just says pick up and drop off, at the parent's house. The parent, dropping off normally is the one who is going to take the kids for their time. But that's not always the case. Sometimes the person getting time, but thinking about travel time, thinking about the times when that's happening is important. Sometimes we give like off week visits, especially as a transitionary time, when everybody's getting used to it. So sometimes they'll get the other parent who has less time will have a midweek visit, with the kids. So all of that can get worked out as far as what that timing looks like, and being conscientious about how much time and building that so that it makes sense, and you actually get, the parent gets, good positive time with the kids and not just sitting in a car. So, those are the things that we think about when we're thinking of timing and traffic and who's doing the exchange. But typically there will be some sort of exchange language. Normally it's at the house. Sometimes it's halfway in between. Sometimes, for more domestic violence type situations, it can be at a police station. It can be at a fire station. So there's a lot of different options.
So they can handle a lot of situations. Do parenting plans talk about, missed visitations or makeup visitations, or times when someone is delayed? I mean, because I know those can be like points of contention. Can a parenting plan deal with those kinds of issues?
It can, if the parties want them to. If they can be silent as well to all of that. So the default would be no makeup. The default would be, that you still get your time. A lot of times, because we see that's where a lot of fights are later, when parents don't have the specificity in those areas, that's a point of contention and an area for modifications a lot, which is, do I get makeup time, and what does late mean? And so a lot of times it can be 30 minutes late, and it's all reasonableness, but unfortunately not everybody can be reasonable. So sometimes you do have to have very, specific language in there about what that looks like. So yes, it can deal with it if it needs to, but it doesn't have to. The other piece that I think is something that a lot of parents hear about, which is called right of first refusal. So like if you're the parent and you are going out of, not even out of town, but say you're going out for an evening or for an overnight, do you have to call the other parent to say, do you want to take the kids or watch the kids while I go out, before I call family or before I call a babysitter? I personally try to avoid rights of first refusal if I can for my clients. I specifically advise them that if there's more fights over the right of first refusal than it helps to solve. I think there's value with small kids and overnights. That makes sense. As the kids get older, they get to go to grandparents for a night, or they've got friends, or they've got whatever. It becomes less and less important, but it becomes a really big point of one parent kind of looking over the other parent's shoulder and just causing more problems than it's worth most of the time. And that's a generalization, but it's just, we've seen so many fights over it that I try to advise against them, except for in limited circumstances.
And it seems like if you get that into the parenting plan, you're going to avoid fights later.
Yeah, I mean, you can, or it causes fights later. So the right of first refusal can cause some fights. But I mean, with anything, again, it's, there's no, I mean, I just really, truly believe there's no one size fits all. So what worked for, what I explain to potential clients is that, as a parent, you're going online, you're talking to your friends who have gone through this situation. So you can gather 3 or 4 pieces of information in order to make these decisions. So you may, one of your friends may have a right of first refusal and you're like, I want that. Well, what the advantage of, or what we do as attorneys, is that we've helped thousands of clients. And so we can extrapolate from all of their cases and help you to understand the pros and the cons of all of these different types of, clauses and options, so that you can build a plan that actually works for you with, I mean, nothing's ever perfect, but with at least the framework, so that it avoid fights and it can save thousands of dollars later by just doing it the right way at the beginning.
Oh, yeah. Kind of that dovetails into, do parenting plans get into like communication issues, how parents communicate with each other about the kids, or information that they share with? Does that kind of go into a parenting plan, or does that fall somewhere else?
Well, there are typically some, sort of clauses that are always in parenting plans that deal with, comments like, neither parent's supposed to disparage the other parent, or not to, have new spouse or new partner be called mom or dad, depending on, gender. So yes, it can go in there. Like with anything, enforceability is always the difficult part, because you're relying on, information that's maybe coming from a child, which, I mean, it's difficult to always know if that's accurate, and judges have a hard time with that, since it's hearsay when they get into court anyway. You can't say my child said this or that, and there's no other real witnesses. So yes, it can, but the problem with trying to hang your hat on that is that enforceability becomes difficult, and it really has to be extreme for a judge to really take notice and do something about it.
Yeah. That kind of leads into the best laid plans kind of scenario. What if before we get into like total modification, let's say there's some temporary changes that you want to make, you'd like to make, or you and your spouse want to make. And they come to you and say, how can we make this temporary change for this summer? I want to do this. They come to you and say, how do I change that? What should I do? Is that?
Yeah, if both parents agree, then it's not required to be in writing to make the change. It can be a verbal agreement to modify the plan for a summer or for a weekend. You don't have to rush to court every time. Plus,
Right.
rushing to court is 8 to 10 months to a year. So, there's no rushing to court. And these are some of the things we help, potential clients understand, in consultations is what does the process actually look like so that everybody understands what they're getting into when they go down the path of a modification. But 99% of the time something needs to be adapted to the plan. And it's my opinion and a lot of people's opinion that that parents should make all of those changes, and those are all verbal changes. What parents have to realize, though, is that the only enforceable plan is the one signed by the judge. So if you go on, and we've had this situation a million times where, it's modified up to, say, it started as an every other weekend and modified up to a week on, week off, and then one parent gets upset at the other parent for whatever reason, and they want to take it back to the every other weekend plan. That's something that, maybe it was over the course of 5 years as they were operating, everything was going on well, but then, things for some reason turned kind of ugly. And so then the other parent's trying to go back to the only enforceable plan. In that instance, there is something that we can file a modification. It's called a post-judgment status quo, where then within about a month, you get in front of a judge and you explain what was happening at the time of the filing, and the judge can reset it back to what it was at that time. It doesn't automatically go to that. But if parents act quickly enough, then you can ask the judge to lock in what you have been doing for that amount of time. So changes are good. The big changes, should be reduced to writing and just modify your parenting plan with the courts, just so you don't have to go through the headache of buying yourself another case in the courts.
So they could, if parents modify a plan, even maybe make a permanent change, and they do it in writing, and they come to you, and I take it then can send that in, and it an order says, okay, this modification is allowed. That can happen without having to go to court physically.
It's called a supplemental judgment. And so then, all of the required documents are required, but we would put all of that into the new plan and get that signed by both the parties, and that gets entered by the judge, and that becomes the new enforceable plan. So that's the document that comes out of either an agreed upon change or a court ordered change. And so it supplements the original judgment, changes those terms, and then you move forward operating on those specific new terms.
Got it. So making changes can be good, but not necessarily relied upon if they're an important change without going to court and actually having it,
Yeah. Yeah, it's the downside of trusting that it can happen forever. But it's important to be able to make changes on the fly. So it's a catch-22 a lot of times. But yes.
But that's the kind of stuff you've seen a lot, and you can help people with, this may be a better situation, or that may be a better situation for doing specific things. Which gets to how are disputes resolved at the end of the day? I mean, what you were talking about, you can modify, you can change it. How is that? What's sort of the process of getting that done?
So it's similar with the original filing. If you, in your original case, you're going through the court system, and if you can't decide, then a judge is going to order it. It's the same with the modification. You're filing to modify the parenting plan. You're going to go to mediation. I believe all of the counties require mediation in parenting plan modifications. And then you would, if you can agree, then you change the parenting plan. If not, then a judge would decide just on the parenting plan if that's all you're asking to modify. And again, that's in the best interest of the kids. And so you're going to be talking about what works for them and what doesn't work, and working towards that modified judgment.
So that then goes to how can you force your ex-spouse to comply? I mean, what happens if they just don't comply? And what can you do?
So yeah, there are, they're not perfect remedies, but there are remedies built into Oregon statutes. There's enforcement where you're asking a judge to enforce the plan. And then, in some instances you can get into, contempt. Contempt is typically not used for, for just straight, compliance issues on a parenting plan. Normally we would use an enforcement action, but that's something that we help potential clients think through during the, consultation and the initial stages of the case to determine what's the most appropriate action to bring for parenting plan compliance problems.
It's kind of one last thought. Someone may come in and say, because this is going to be a fair amount of work at the front end, getting a parenting plan, getting one that you can agree to, getting it, set, get it and get on the record. So, what about, someone saying, why to go to all this work to negotiate a parenting plan? I mean, why don't we just sort of put in something and then worry about it later? How do you respond to that?
Yeah, I mean, I think every situation's different. Sometimes it works, but I think the downside of not having something written down is outweighs just kind of figuring it out. Just because you've got kids involved, you've got two parents involved, you've got multiple lives that are constantly changing, and you're trying to figure out. So getting something at least in the court so that it is consistent with what your original plan is, regardless of what that plan is. At least there's some safety on both sides, that the other side isn't going to withhold from the other parent, because that's where things blow up, where you have parents who are trying to operate on their own accord, but then one parent does something and then another parent they retaliate by withholding the kids or trying to move or what have you. So there's a lot of reasons to just have something written down in writing and that's enforceable by a judge, so that way you protect your rights and you protect your what you understand the parenting plan to be, and then you can work from there. But it just becomes a situation where it's a lot easier when everybody's in agreement to put something in writing, because when it blows up that way, it's going to be a lot more expensive. It's going to take a lot longer, and you're just going to have to be fighting all along the way to get back to where it once was.
So if someone is listening to us today and they're looking at their parenting plan and said, well, I don't I have questions about it. You've said a lot of things, and I'm not sure that mine is really the way I want it to be right now. What should they do?
Well, we provide consultations all the time for potential clients looking at parenting plans and understanding what the changes to make a recommendation, whether a modification is the right course of action, and so we offer those consultations all the time, and so that would be the first step. Attorneys who are practicing family law, we see modifications and we see parenting plans all the time, and so that allows us to give the information from a standpoint of, in this county judges do it this way, and in this county judges do it a different way. We've got offices through a lot of Oregon counties, and so we're able to give that guidance as far as is this worth bringing a modification, or do you just go to mediation and try to work this out, or through negotiation? So we try to advise clients in that respect.
This is one of those things that it's simple, but it's not simple. There's a lot of things that you really need to know, and specific things you have to do. So, thanks again, Lewis, as always, for joining us today and giving us insight into really how important parenting plans are, and why you need to be aware of them and take care of them if you have to. Thanks again for coming.
Yeah, you're welcome. Always happy to jump on a Facebook Live and talk to you, Steve. And I think the last thing I would say is that a lot of people get caught up on the term custody, and while custody is important, just to kind of go back on what I talked about before, the parenting plan is what you live with 365 days a year. Custody comes up maybe a couple times in a kid's life. So, I would definitely get more information on the parenting plan, reach out, find as many resources as you can so that you can make informed decisions.
That sounds right. Thank you again. Thank you so much. And, I want to thank everyone else who's joined us today, tuned into our Facebook Live. Anyone have any questions, as always, on today's topic, you can post it. You can shoot us an email. I'm Steve at landerholmlaw.com. You can call, set up a consultation. We do this a lot. We're experts. And like Lewis said, we are all over the state. So feel free. And again, until next time, everyone, stay safe, stay healthy, have a great day. See you next time.